Welcome to the land of 10,000 claims. Today we go into part 2 of our video about miners. Now, as you'll recall in the last episode, we talked about mining accidents and dependency benefits, and we went over the Milford mine disaster, which is the worst mining disaster in Minnesota state history. Today we pick up right up from that discussion with Mike explaining how many miners were lost in any given year. And then we go into talking about the suicide defense. Now, I know suicide is a very difficult topic for many people to listen to. So if that affects you, I would recommend not listening to this episode. However, I think it's an important topic to go over because you'll hear about how some of these employers and insurers would deny cases based on how someone looked on any given day of work. It's a pretty interesting topic. So like I said, you've been warned about the topic. And welcome to the land of 10,000 claims. Thank you for joining us.
So the end reality of all this is that between 1915 and 1930, about 3,000 to 4,000 miners in the United States are dying. And the first case where the suicide issue comes up in Minnesota with a mining case is the Arco case. And basically what happened in that was, again, it's what I mentioned earlier. This miner is working with a coworker and then leaves to go to another area of the mine, and there's an explosion that's unwitnessed. Obviously, the effects of the explosion are witnessed, but not how it actually occurred. He's found 100 feet from where he was working. He's dead. His chest and an entire abdominal cavity were blown apart. And the mining company chose to employ a suicide defense. They said that, and these are quotes from the case, that the employee, quote, wasn't feeling right that morning and, quote, didn't look natural, close quote, that morning. Basically trying to portray the employee as depressed. And they didn't have much more to go on than that, which kind of boggles the minds. And in today's practice, you would have to have much more to viably move forward with the suicide defense than he looked a little grumpy or down that morning.
That was kind of the common thing with a lot of the immigrants at the time, though. I mean, you have these
Well,
Northern European people that
we were
aren't inherently talkative.
yeah, we were talking about that off air. That, I mean, Swedes and Norwegians, if you knew anybody that were brought up in that era, it was kind of the strong silent type, and you might not have a great big smile on your face when you're about to go into a mine for 10 hours a day too. So even that
It was a
context.
normal, yeah, it was a
Yeah.
normal everyday thing for them.
The good news is the court doesn't buy it at all. And they actually create this presumption that, quote, when violent death is shown, the presumption arises that it was not self-inflicted, close quote, meaning that basically the more violent the death, the less likely it was suicide. And we were chatting about this as well. It's kind of pulled from nowhere, but my instinct was, where did they come up with this? My instinct, and I'm not sure of it, but was, we're again talking about the 1920s. We're talking about an era where people were much more religious. We're also mainline religion teaching throughout all the major religions was uh, eternal damnation if you committed suicide. So I'm thinking that that this was a bit of a generational reflection by the court when they created that presumption.
Well, that and, we could know more about it if it was actually legislative, if it was actually done in a statute. But what happens here is the court says it, so we don't know where the court got it or what their bottom line reasoning was, because they just issued the decision, they put their thought process in the decision. Whereas if it was legislative, they would have debated it. There'd be committee minutes and things like that. But it never goes through the legislature. Like the presumption against suicide does not reach the Minnesota legislature. They don't put it in statute. And the downfall to that is we actually don't get to know exactly why they wanted to do it. So I suspect, like Mike, that it probably had a religious aspect to it, but I don't know.
So then that brings us to 1923 at a case called Hawkins. And this guy was not a minor. He was a delivery driver, found shot to death on Minnetonka Boulevard. The wound was from a 22 caliber bullet. It entered his chest and passed through his body where it lodged in his back. Much of the cargo had already been delivered, so it was hard for investigators to determine whether anything had been stolen from the delivery van. His body was found with his vest open, his right pants pocket pulled out, no money on his person, his watch chain. Remember that you'd have a hanging watch or a pocket watch back then. That chain was broken and hanging out from his vest pocket. There were 2 spent shells on the seat, and the truck was in gear and the ignition was on. No firearm was recovered from the scene, but it was in evidence that the employee had recently purchased a 22 caliber firearm. So the question then becomes: was he robbed and tried to use his own gun to fight them off? Was he just robbed and murdered and they made off with his gun because that would have been a valuable thing? Obviously, the facts with the pants pocket, the watch, the fact that he has no cash, those are all pretty indicative of a robbery. Um, I don't. This is another one that's confusing to me of how the insurance company ever thought that they were going to prevail on claiming that this was suicide.
Yeah, haven't you ever heard about someone, shooting themselves twice and then having the gun
But
fly away?
robbing themselves first.
Yeah.
And throwing it all away.
Yeah. Yeah, in this one, the Supreme Court seemed pretty annoyed at the suicide defense. They talk a good amount of the case in their decision about murder and if that would be covered or not, which is fine, but they they are getting annoyed at the suicide defense and basically saying like, why did you bring this up? Um, and really, this is where it goes from, it's not mentioned in statute to now the Supreme Court's been so clear. They mention it when they publish the 1927 list of statutes. So even though it's not in statute, it gets published with statutes that there's a presumption against suicide because the Supreme Court was mad enough about this that this is the direction they went. But really what it doesn't say is, was he looking sad before he was shot
Right.
twice? Because that would have been the suicide defense there.
Right, and that comes back into play in 1927 in the SAMHSA case. Um, Similar evidence about the employee, similar situation in that he dies in an unwitnessed explosion. Um, but the evidence that was entered that I said was similar to the other cases was he didn't look like his usual self. He was pale and he was unresponsive to his fellow workmen when they spoke to him. Uh, at trial, the court determined that the injury was a suicide. The Supreme Court didn't want to disturb that, and I think the biggest fact of why they didn't do it is this particular employee, where he was found, where the explosion occurred, was not an area he was supposed to be working in, and he was not involved with the use of explosives, um, which is almost more of a prohibited act defense than a suicide defense. But we'll talk about that in a future episode. But I think that key factual distinction between ARCO and SAMHSA can't be understated. That in ARCO, the guy's job was to use explosives. He was exactly where he was supposed to be. In SAMHSA, he wasn't supposed to be using explosives and wasn't supposed to be in that area of the mine. So um, that's a distinction that can't be missed. And
I think the message the Supreme Court was trying to say in that one is that the suicide defense isn't gone, but we would like you to go a different direction with it because it does seem like it's more misconduct where someone's doing something so far outside of their normal job that it wouldn't be covered. And I think it's kind of the precursor to that is, we're not going to accept a suicide defense, but we'll look at it if you start bringing some of these other defenses to us. And I think this is kind of one of the earliest signs of the Supreme Court wanting to see that difference.
I think that's a good read on it. And and I think they solidified that type of thinking in the Centuri case. This was in 1935 is when this gentleman died. He was using an axe to chop a fuse on a piece of dynamite, and he made it too short. That was undisputed, that's what caused the explosion. What was disputed was whether he did this intentionally to commit suicide, or whether it was just an accident, meaning it was a result of his own negligence. And the lower court, the trial court, determined that it was not a suicide, and the Supreme Court basically found no basis to second guess that. But more importantly, in that case, they had a commentary about how we're not going to start bringing employee negligence into the analysis here, because the whole point of the workers' compensation statute is that the employee's negligence is not a defense. You can be as negligent as possible in the infliction of a work injury, and you're supposed to be covered. That was one of the whole bargains we talked about in our last episode of this compromise system. Employers and insurers get fixed benefits, capped benefits, and employees abandoned. Employers and insurers also, though, abandoned the negligence standard for a no-fault standard. And this was a clever attempt, I think, by the mining company to slide negligence back into the analysis. The Supreme Court saw it for what it was and told them to bugger off. We do, though, then come to the question of a prohibited act, that there are cases on that. And basically, if there's an absolute prohibition on doing something at work, and you do that and that's what causes the work injury, then you can recover. However, in reality, that's been very difficult to prove, because it has to be the act that's prohibited, not the way in which you're doing it. Most of the time, it's misasserted by the insurance companies in cases where it's actually someone doing things in a prohibited manner rather than doing an actual prohibited act. So, and we could talk about that on a future episode, but it is interesting here how not even 22 years into the life of the statute, the employers and insurers are trying to rewrite the ball game and throw negligence back in.
On where the quote on what happened and how the Supreme Court kind of put it, his injury was pretty graphic. So to quote the exact case is that his heart and vital organs eviscerated by explosives that had torn a large hole in his chest and cut off his left hand. Like, that is that's something I was not expecting to read in a Supreme Court case, but they really did spell it out. And this one's another one where they raised that he was looking sad and depressed. But they had testimony that he had a happy life with his wife and children, was cheerful, although a little bit quiet. But yeah, they said that he looked ill that morning. He might have been depressed at lunch. Like, it really makes me self-conscious if I have to go in the office. Like,
Yeah.
am I looking good enough to not be presumed to wanting to kill myself? Like,
Everybody's got good days and bad days.
yeah.
You know, you're also talking about a time when people did not have regular access to clean food and clean water.
Yeah.
Or
That's a very good point.
or routine and preventative medical care. I mean, that to come in looking ill, maybe you ate a piece of salted venison the night before that is well past its prime because you don't have a freezer, so you just salt cured it and hope for the best. I mean, or drinking adulterated alcohol, that was common at the time, homemade alcohol. Medicines weren't even really regulated that heavily at that time.
A lot
The
of snake
FDA,
oil out there.
yeah. So the fact
Did
that one
Coke
would
still
come
have
in
Coke
ill.
in it at that time?
No, I think it was out by then,
Okay.
by the 30s. But, yeah, all that's. I mean, this is back when they told you smoking would peak you up, make your color look better. So a lot's changed.
Well, and mental health treatment just wasn't
Right.
than
a
what it
thing.
is now.
Yeah.
I mean, and I don't know. I just think about when I worked at Super America, like walking in every day. Like, yeah, I wasn't working in a mine where I'd be 10 hours in the dark, but I can't imagine I was walking with a skip in my step most days going to work and run a gas station. Like,
I don't know that there's anyone out there really that was just super joyous to go to work every single day of their life.
well, apparently the employer and insurer thought so because it was weird when someone wasn't up for it. So at the end of the day, we wouldn't want to be minors. And these are just some of the reasons. There are obviously more because it's just a heavy backbreaking job even when you don't get hurt. So, you add in those early issues with dependent benefits, with suicide defense, and it just makes for working conditions that we're glad we never had to do. We got to be lucky enough to be lawyers. And my takeaway when I read these cases and did some of this research is that the way we look at mental health now is very different, especially in the context of the suicide defense, and the way we value dependence and the different types of dependence you can have now versus then is very different, because I think what's happened is as we've gone forward, the legislature and the court have both recognized that we have bigger families and different types of dependents, and that's really expanded those benefits. And they've understood that, violent death is not something that most people choose. So things have gotten better, but still, even to this day, I would not want to be a minor, but there aren't nearly as many of those in Minnesota as there once were. Do you guys have any closing thoughts?
Yeah, I have a client that's a minor, actually.
Yeah?
And he's very fun to talk to. Very much enjoys his job. It's heavy duty labor. It takes a certain person to do it, and a lot of respect for them to do it. I've got 2 bum shoulders now, so I really can't do any physical work. I can't even mow my lawn at the moment. But yeah, it's I think you're right with the mental health aspect of it. There's a lot more mental health claims that we'll talk about in a later episode as well. There's some aspects of that can be compensable.
Also, the to stress again how poor the conditions were, that's also what led to the unionization of miners. That played obviously a massive role in not only national politics, but in Minnesota politics in particular. The the unionized mine workers in particular up north were tremendously influential on the left in the state's political history, and the mining industry was particularly impactful on the right. So um, the fact that they found the ore up there set off a completely changed course of history, even though they didn't find gold.
Yeah. And when you're looking at those dates, it's completely understandable why the unions needed to do what they did, because between workers' compensation starting and any federal protections you get, there was just not a lot to protect miners. So if you don't have someone to protect you, you got to find a way to protect yourself, and that's what they did. So
Rusty gold. Some people would call it rusty gold.
Rusty gold. And you know what? If there is a way that you guys know about to get gold out of granite, let me know. We'll see if we can make something happen. But
yes, absolutely.
But
that is environmentally friendly, because I'm sure there's ways we can do it with like chemical leaching and stuff.
We won't even go down that rabbit hole.
No.
But next time we'll be doing something a little bit more lighthearted. I know, more lighthearted than dependent benefits and suicide. How can we possibly do that? But no, next time we'll look at workers' compensation in popular culture. We'll break down some of our favorite TV shows, talk about the work-related issues there, and give you a breakdown of if it would be compensable in Minnesota and what the issues are there. Thank you for joining us on in the land of 10,000 claims. Thanks.